And that leads me to introduce our next speaker, Dr. Geoffrey Shannon, who is an expert in this field. I have to say, I know Geoffrey very well. He's our founding patron of the Children's Rights Alliance. But he's also a senior counsel, a practitioner himself, an academic, and he has served several terms as our Special Rapporteur on Child Protection in Ireland. But one of the things that's really useful, I think, and Geoffrey may speak about it, he was chairperson of our Adoption Authority. And the Adoption Authority of Ireland did do a review to embed the voice of the child and to make the authority more suitable and friendly, and adapted their procedures to accommodate young people. You know, a real model of how you go forward and do this as a piece of work. I talked to some participants at the lunch break about the positives in Irish law, and one of those positives is we have a defined best interest principle in our Children and Family Relationships Act. I know Geoffrey would say it's first in class, or it's definitely best in class in terms of an approach, and it's one of the big challenges is the best interest of the child is not defined sufficiently to guide decision makers and practitioners that might want to promote the best outcomes for children and young people. So Geoffrey, I will invite you to take the floor.
Good afternoon. Just want to start off by saying what an enormous pleasure it is for me to be invited to speak at this very important gathering. And I think we will all come back today to the really powerful interventions by the four young people. I just want to salute the outstanding work and the outstanding ambassadors you are for young people and for this issue. So on our collective behalf, I just want to express our deepest gratitude for what for me will always be the high point of today's proceedings. I think it's a measure of any democracy, the manner in which the needs of the most vulnerable are considered and met. And I think we have a real opportunity today in this conference to focus our minds on the issue, the best interest principle. And what I've been asked to do is to look at the evolution of the best interest principle in the Irish context. And I think we can be incredibly proud of the manner in which we have embedded in a really meaningful way the best interest principle in both our childcare proceedings and in our private law proceedings. And if we start off by looking at, I suppose, any democracy, and I think our own democracy, and democracy is such an important word in these times. In fact, one of the founding principles of this nation, it's an often misused word, is cherishing all of the children of the nation equally. And that's so hugely important. And when we come to draft any document, it's hugely important that no child is left behind. And I was really struck by the issue of delay mentioned earlier. Delay is hugely corrosive in terms of decision making. Childhood is for a limited period of time. And if that childhood is interrupted by a negative event, that can have profound consequences. So I think we all need to redouble our efforts to ensure that decisions are taken in a timely manner. The principal source of fundamental rights in an Irish context is the Constitution. And recent legislative and constitutional changes have placed the best interests of the child at the core of our decision making. 2012 was a very significant year because that year the Irish people voted to enshrine a provision in our Constitution stating that children matter, because children were not visible in our Constitution until that particular moment. I remember at the time, in the aftermath of the referendum, people talked about the change as being modest change. It is my passionate belief that incremental change is the best type of change. And I have a very recent up-to-date Court of Appeal decision where we see the practical benefits of this constitutional referendum. So while it may not be evident immediately, over time, change embeds itself in a way that has a profound impact on children in particular, but on vulnerable people as well. Article 41 of our Constitution recognises the family as the primary and fundamental unit group of society. And up until that time, the focus was pretty much on the parents. We inserted a provision in our Constitution which made visible children. And I think the wording of the text in Article 42, which is the provision that existed, is now to be reviewed and is to be looked at through a more child-centred counterpoint. And one of the key provisions that the Irish people voted for is it mandated the state to insert a provision across our statutes to ensure that the best interest of the child would be a primary consideration, which in itself seemed rather academic at the time. But if we look at the very significant progress that we have made in the intervening period, I think by any standards it's quite outstanding. Because as a result of this provision, the child's welfare and well-being is the cardinal principle to which the court should direct itself in care, adoption, custody and access proceedings. And this is not to suggest that other considerations should be ignored. The section clearly foregrounds the best interests of the child as the first and paramount consideration. And that provision in the Constitution needs to be looked at in the context of two prevailing assumptions. And the first of those assumptions is that married parents are presumed to act in the best interests of their children. And the second presumption is the child's best interests are generally best served in the custody of their marital parents. But that presumption can be rebutted. And we see in a recent decision of the Court of Appeal during August how the constitutional referendum had a profound impact on how that decision of the Court of Appeal was ultimately decided. So where have we come from? We've come from a situation and if I can divide it into three. Firstly, we have our private law statute, which is the Guardianship of Infants Act of 1964, and that talked about the welfare of the child being the first and paramount consideration. And what I challenge you to consider today is moving away from welfare, which is quite paternalistic, to best interests, which is a much more empowering concept. So that was in our governing statute around private law proceedings. I chaired the Adoption Authority for a period of 13 years, greatest privilege of my professional career. And when I took over as chair, and I heard cases every Tuesday, so I felt enormously privileged because I got to hear the voice of children, those who are going to be directly affected by decisions. I was really struck by the last presentation because that's really what's important. It's not a tokenistic approach, but hearing children in a really meaningful manner and providing children with the outcome of those proceedings. So under the old, what was Section 2 of the Adoption Act of 1974, you had a similar provision that the welfare of the child was the first and paramount consideration. So that's the second set of proceedings. And Diego mentioned this morning, in childcare proceedings, there were two provisions. First talked about how the Child and Family Agency should deal with cases, and that talked about the welfare of the child being the first and paramount consideration, and how courts under Section 24 of the Childcare Act should regard the welfare of the child as the first and paramount consideration. So when the referendum result was finally ratified on the 28th of April 2015, the Irish state had to go about modernising its laws. And that, in terms, as if it was planned for this conference, that process concluded last week as a key provision of the Childcare Amendment Act was commenced. So I think it's one, and if we can look very briefly at that journey, because it was a journey. If we look at under the old law, judges were very favourably disposed to children. In a leading case called G versus An Bord Dubh Táille, a very important judgment in the adoption context. They talk about the word paramount by itself is not by any means an indication of exclusivity. No doubt if the Oireachtas had intended the welfare of the child to be the sole consideration, it would have said so. The use of the word paramount certainly indicates that the welfare of the child is to be the superior and most important consideration. The ostensible rule then, under the prior law, was where there was a conflict between the welfare of the child and other considerations, that the welfare took precedence. So along comes the first piece of legislation. I think the Department of Justice deserve a huge amount of credit for the Children and Family Relationships Act of 2015. It was a groundbreaking piece of legislation, bringing a diverse range of family types in from the cold. What it seemed to do, it seemed to build rights around children rather than around their parents. So it swept away what I would characterize as discrimination against certain family types. And that piece of legislation is a very progressive piece of legislation. And I draw your attention to two provisions. And just in case I see some people taking notes, I prepared a detailed paper which I'm quite happy to circulate to people. The first of those provisions is that in Section 45 of the Children and Family Relationships Act, there's a provision that the best interests of the child shall be the first and paramount consideration. But more importantly, particularly for the next 2 days as you deliberate on guidance on best interests, was Section 63 of the Children and Family Relationships Act set out 11 factors a court should take into account when determining guardianship, custody and access cases. And there are two characteristics of Section 63 that I would draw to your attention. The first is they're non-hierarchical, which I think is important. And the second is that they're non-exclusive. So these aren't the only factors, but what they do is they provide a framework for decision-making. So what we've swept away is what I would call the very broad discretion afforded to the courts under the pre-existing statutes. And we now have a framework for judges to make decisions on custody, guardianship and access. And that also leads to accountability. Because when we talk about how we should embed best interests, it's that it would be transparent, but also that decision makers should be held accountable. I moved then to look at the next provision, which was in the adoption context. And as somebody who dealt with these cases every Tuesday, I always felt under that the Section 2 of the Adoption Act of 1974, which was carried over into Section 19 of the Adoption Act of 2010, when Ireland ratified the Hague Convention. But we carried over the welfare principle. So in the Adoption Amendment Act of 2017, the best interest principle was enshrined in adoption law. And for me, at a practical level, that made a very real difference, because you were no longer talking about this general feel-good concept of best interests, but you had a framework. And for the first time, you had to take into account the child's age and maturity, the physical, psychological and emotional needs of the child, the likely effect of the adoption on the child's views, the child's social, intellectual and educational needs, the child's upbringing and care, the child's relationship with his or her parent, and any other circumstance that you deemed to be relevant. So what I did at that stage is that I worked very closely with my friend and colleague, the Ombudsman for Children, and I said, this is a real opportunity for us to look at how we hear children. So I subjected the authority to a review by, and I see Dr. Cara McCauley, who were enormously generous in assisting us to walk the walk on hearing the voice of the child. And we developed protocols around hearing the voice of the child so that we could give effect in our determinations to the best interests of the child. And it is my proudest achievement within the authority, because I think it's a legacy piece that you leave where you can genuinely say is that there is a transparent system for hearing children. And the most powerful testimony you're ever going to get, and I'm sure Judge Daly is going to touch on this later, is when you hear directly from children. But sometimes they're much more articulate than the adults, and they're much clearer in what they look for. And I think that that's something that we shouldn't lose sight of, because sometimes and I was really struck by one of your slides where you talk about, this issue of listening, but listening in an active way. And I think that that's something that we shouldn't forget. So what we had there was, again, a non-exhaustive list. and a non-hierarchical list. And the final provision, which was the Childcare Amendment Act of 2022, where finally, and it was one of the recommendations I made as the State's Rapporteur, is that we should have a best interest principle in our Childcare Act. And we now have. And Diego Gallagher talked about those factors, so I'm not going to go through them again. But I think it's important in terms of decision making. And as you consider your guidance over the coming days, what Ireland did is it had an enabling provision in the Constitution. So the best interest principle is not enshrined in the Constitution. It's a very useful judgment of Mr. Justice O'Donnell in a case that I was involved in as chair of the authority, my work with the authority. But he talks about it being explicitly a requirement to introduce into legislation dealing with specific areas a provision requiring that the best interest of the child be a paramount consideration. So the provision shall be made by law is not merely a well-worn constitutional principle, but rather has substantial importance. The area for decision-making in which the best interest is to apply is defined by the statute. So what we have done is we've created that framework, but the detail is in the statute. So what you're going to need to consider as part of your working group is how the Council of Europe member states should incorporate a best interest principle. And I'd give you, I suppose, the most recent example in an Irish context. And we had, I suppose, a case in the immediate aftermath of those comments by Mr. Justice O'Donnell in a case called a foster mother versus CFA, where the High Court judge, relying on the judgment of the now Chief Justice, said that Article 42A.4 cannot be relied upon directly, but through legislation. But to give you a recent example as to how it has made a difference, I'm going to reference a case called Child and Family Agency versus the Adoption Authority of Ireland, and it was a judgment handed down by the Court of Appeal in August. And maybe at a very simple level, when a child's been in the care system and that child wants to be adopted, the application is taken by the Child and Family Agency. And up until the Children's Right to Referendum, a child who's in the care system seeking to be adopted, the threshold was very high. That was lowered by the Adoption Amendment Act. So the proofs required is that you had to demonstrate the child had been abandoned really for a period of 36 months. In other words, the parents had failed in the duty of the child in a manner that was likely to prejudicially affect the welfare of the child. They had to prove abandonment on the part of the parents of all constitutional rights, and that it was appropriate for the state as guardian of the common good to supply the place of the parents. And this is a very interesting case. In this case, the child was 17 and a half. So the child was on the cusp of becoming 18. And what it brings into sharp focus is why it's important to have visibility for children in the Constitution. So the case went before the High Court, where the Child and Family Agency was seeking the authority of the High Court to allow the Adoption Authority to grant an adoption order. And what the High Court judge said in this case is he looked at the facts. He said, well, we have a case here where the child was placed in a matter of months. The child had a very loving relationship with the foster parents. And in addition to that, is the child wanted to be adopted. And this is about hearing the voice of the child. The child also had a good relationship with the birth parent. So the High Court judge seemed to place excessive emphasis on the rights of the birth parent and declined to allow the order. But when it came before the Court of Appeal, there's a very interesting judgment of a former Attorney General, Mrs. Justice Whelan, who gives a very considered judgment. And if I can share with you just some of her comments. She talks about the court having placed particular emphasis on the physical, psychological, and emotional needs of the child. But what she stated very clearly is that the trial judge had placed insufficient weight on the fact that the adoption would provide continuity to an established long-standing relationship with the only person loco parentis to the child. Despite agreement by the birth mother that the child did not or could not be cared by her, and in addition to that the child had never during her lifetime been cared by the birth mother, the trial judge nevertheless placed a higher emphasis on the views of the mother rather than the express opinion and ongoing needs of the child. And this is where, what happened is the majority of the Court of Appeal, led by Mrs. Justice Whelan, decided to give weight to the best interest principle. And this is a very practical example where the best interest principle made a very real difference to a child who wanted to be adopted. So I thought you might find that interesting. Another interesting point is whether you should introduce a wide provision in the Constitution dealing with best interests, or whether it should be more focused. And I have in the paper, which I prepared for you, a very detailed narrative on where this has occurred and where it has worked. So I cite the South African Constitution, where the scope is very broad. And I argue that a very broad best interest principle, I suppose, has a number of risks. It leads to a lack of uniformity. It risks inconsistency and unpredictability. So we need to be very careful of that when we're looking at best interests. And the indeterminacy of the best interests leaves, if it's very broad, leaves it particularly susceptible to judicial prejudice and assumptions. So there are two options. One is you define best interests, which I would caution against. Or the second option then is that you have guidance, which is really what you're embarking on. I would, in terms of something like the South African Constitution and that model, I think if it's defined at too broad a level, there are implications in terms of competing rights. There's the risk of best interest as being a supranational constitutional value. So I know I'm coming towards the end of my presentation, but I just want to address very briefly the broader Council of Europe framework. And it's so fantastic for Ireland to be part of this international community. So what I have in the paper is I've drilled down through the models throughout the entirety of the Council of Europe. And I've come to some conclusions. So I'll just share some of those conclusions with you. The first is the European Court of Human Rights is such an enormous resource. But I think the challenge for the Council of Europe is the fact that you have conventions such as the Contact Convention of 2003, where not all states have signed up to the Contact Convention, and that leaves it's more challenging. The same with the European Convention on the Exercise of Children's Rights. I think we should encourage member states to ratify those very important instruments, because there are two key children's rights principles. If we look at Article 7 of the Contact Convention, or Article 6 of the European Convention on the Exercise of Children's Rights. But the challenge is that not all member states. And there's added complexity then, because the European Union has the Charter of Fundamental Rights. So we've got Article 24 of the Charter of Fundamental Rights. We've got the Brussels II bis regulation, where best interest forms part of the Brussels II bis regulation. For example, the best interest of the child is one of the grounds for non-recognition of judgments. And again, further change with the Brussels II recast, which has similar best interest principles. So that creates its own challenges. So what is the framework and what is the model that we should use? Well, if we look at the common trends, we see that the wording often used is that reflected in Article 3 of the Convention on the Rights of the Child. The wording is often undetermined and vague. The legal provisions are unclear, and that leads to a wide margin of interpretation and discretion. A review of the national laws shows there is no uniform legal wording concerning the best interests of the child, and there are significant differences in the level of discretion left to decision-making bodies. And I think that needs to be looked at. And why this conference comes at a great time is that when you look at the majority of member states, they have what I would characterize as weak orientation for the best interest determination procedure. And what the guidance will provide is much greater strength in that orientation procedure. So two options. The first option is you define best interests, which I think would be a mistake. The second option is what you're doing, which I commend, and that is you're reflecting the approach in General Comment number 14, and that is that you would have a non-exhaustive, non-hierarchical list. So what I urge you to do is to provide that type of guidance to member states. In my opinion, legally binding criteria has great benefits in guiding the interpretation and application of the best interest principle. Where these criteria are absent, decision makers enjoy a high degree of discretion. There's a high risk decisions are made on personal perceptions, and there's a lack of accountability. So that's why having those criteria and that framework leads to much better decisions. So in conclusion, what I would be saying, and certainly my own view, is that there is no convention on guidelines that exist for, I suppose, trying to, in a coherent way, bind together all of those aspects, because what we now have is, and what we need an instrument that captures all of these issues. What I am suggesting at Council of Europe level is that there's no convention or guidelines exist which specifically bring together and I suppose in what would be a coherent fashion the needs of children in situations of parental separation. And I think that that's something that's needed. What I would also say is there's no common strand of who is to be considered a parent. You know, I think that that's something that we need to address collectively, and there's an absence of common terminology and a lack of common legal concepts. And these lacunae assume increasing importance given the importance of cross-border restrictions. And I'll finish now, as I see Tanya, if I could bear with me, just to make some very final observations. And 30 minutes is so short, but it is my view, when parents separate or divorce, it's not just the adults who are affected. Children are deeply affected as family routines fall apart and parenting skills are diminished by a looming marital split. And I was really struck by your presentation because divorce comes as a shock for most children, separation, and usually provokes an emotional crisis akin to a bereavement. And there is a paradox there, because the law aims to make the welfare of the child paramount. And aims to have the best interests of the child as the centre. Yet how can we, if we don't do what we did this morning, listen to what children have to say, hear them, understand what is happening in their lives, and meet their emotional needs at a time of intense emotional family upheaval? I think we're now at a crossroads. We're poised between a traditional assumption that children are protected best by keeping them ignorant of their parents' circumstances, and a newer idea that children need to know and need to be involved in the decision-making process. I believe that all children have the right to survive, grow and develop in a context of physical and emotional social well-being. I believe every child should have the potential to achieve what he or she wants, and we've seen that this morning. I finished by saying the manner in which a democracy treats its vulnerable citizens reflects not only its qualities, but also its sense of social justice, its commitment to the future, and its ambition to enhance the human condition for the next generation. Thank you very much for your attention.
Thanks, Geoffrey, for an excellent elucidation of the best interest standard. I mean, it's such, your paper, which no doubt hopefully will be emailed to everyone, all the experts for a meeting tomorrow and Wednesday. I see someone, see high-fiving on that. So it's just a huge resource and tool for anyone doing work in this area. And, you know, Ireland has developed the model, hasn't quite developed the model when it comes to the voice of the child in private law proceedings, but that might come up in the next session, which is going to be led by the Ombudsman for Children. So thank you, Geoffrey, for outlining that. That's a really great start for us for the rest of the afternoon.